I'm delighted to be able to introduce this morning our distinguished lecturer for this year's summer course. Some of you may know every year, as part of the summer course, there is always at least one and sometimes two distinguished lecturers who are invited to address a topic connected to the course, if not necessarily, strictly speaking, within the theme of the course. Given that the theme of this year's course revolves around sources, we were really delighted when Sir Michael Wood accepted our invitation to give this lecture on customary international law, which, as we know, is one of the consecrated sources of international law. Sir Michael Wood is currently a member of the United Nations International Law Commission and serves as the Commission's rapporteur for its ongoing study on customary international law. He's already issued in that capacity two, I think, reports, which have had, I think, some influence in the ongoing, one might say, never-ending debate about how to think about customary international law today. Sir Michael is currently a practicing barrister, an advocate, and has, in that capacity, has represented a number of sovereign states before the International Court of Justice, including Peru, Kosovo, Ukraine, and before the European Court of Human Rights, Turkey, among others. And from 1999 to 2006, he was the principal legal advisor, or what the British called the legal advisor to the Foreign and Commonwealth Office for the Kingdom of the for the government of the United Kingdom, including during that period time spent in New York as the United Kingdom's mission to the UK mission to the United Nations. So it's really a great pleasure to be able to introduce Sir Michael today to address you all. Just one small administrative matter. I think you know that in the afternoon today at 2:15 there will be a short session concerning the diploma examination. For those of you who wish to take the diploma examination, there will be a little bit of information about the nature of the exam, which will take place here at 2:15. So, without more, then I will hand the floor to Sir Michael, and I look forward to his presentation. He tells me that he's going to speak for about 40 minutes, and then the rest of the time will be devoted to questions. Sir Michael.
Well, thank you very much, Nehal. You omitted to mention that I also acted for Timor-Leste against Australia in the case involving Australian espionage and seizure of documents in Canberra. And also one case where I was actually on the side of human rights, which is a bit unusual for me, Belgium against Senegal, where we were arguing for the trial of Hissène Habré, and the court unanimously ordered Senegal to conduct such a trial promptly, and we were fortunate there was a change of administration in Senegal at the same time, and they did indeed do just that. You mentioned that I was a lawyer at the Foreign Office, the British Foreign Office. I was the senior lawyer from 1999 to 2006, but I was actually there for 35 years. So I have to say I'm very much a government lawyer. I'm not a human rightist in Professor Pellet's meaning of the term. During the time I was the legal advisor at the Foreign Office, I suppose the most important issues that occurred concerned the use of force. When I took over, I prayed for peace, 5 years of peace, and what we got was Kosovo, the attack on Serbia over Kosovo in 1999, the attack on Afghanistan in 2001, and then the attack on Iraq in 2003. So my legal advice was much involved in those matters. I advised that it was unlawful to attack Iraq, but the Attorney General disagreed. And the outcome of all that is going to be in the Chilcot report, the UK's Iraq inquiry, which is to be published finally on the 6th of July. So I'm looking forward to reading the 2,600,000 words of that report. It's a very great pleasure to be here. It's my first visit to the EUI, and it's a particular pleasure to be with the participants in this human rights summer course. As you said, I propose to speak just for about 30 or 40 minutes, leaving plenty of time, I hope, for discussion, because I'd much rather answer questions than just speak. My basic theme, to give the game away right at the start, is that I think that international human rights law is an integral part of public international law. It's not, in my view, a special field. It's not a field in which special rules apply. Inyeta Zimela this morning mentioned reservations. I think that in that field in particular, the better view is certainly that the general law on reservation should apply in the human rights field as well. That's the view that the International Law Commission took, and I think at the end of the day it was also a common view between the International Law Commission and human rights lawyers, though there were some rocky shoals on the way. I think the same is true in relation to customary international law. The customary international law of human rights, in my view, has to be seen as part of general customary international law. I will argue that the same approach, the same basic approach, must apply to customary human rights law as applies to other fields of customary international law. And I think it's in the interests of human rights law that that be so, because I think it means that the customary law of human rights is robust, is more robust as a result. Given that I've been a government lawyer for most of my career, indeed still I tend to work pretty well exclusively for governments, though not only the United Kingdom government now, I'm certainly not one of these human rightists. I've usually dealt with human rights cases from the point of view of the government. I was the agent for the United Kingdom before the Court and Commission in Strasbourg for 5 or 6 years, in the course of which perhaps the most interesting case was the Zering case, which we managed to lose 21-0, which is a pretty good result, I thought. Since then, as Nehal mentioned, I acted for Turkey in the Demopoulos case, which was the final case, at least I think it was the final case, of the Loizidu range of cases, and it ended with a victory for Turkey on the grounds that Turkey had set up in northern Cyprus, and we accepted that Turkey was, for the purposes of the convention responsible for northern Cyprus, a domestic remedy which was sufficient, and that dismissed or got rid of some 1,400 cases, I think, that were then pending. What I plan to do is to describe the International Law Commission's current work on its topic identification of customary international law, but referring, when I can, to the international law on human rights. Just a very brief word about the International Law Commission. I expect you all know what it is. It's a subsidiary organ of the UN General Assembly, composed of 34 persons who act in their individual capacity. At a rough calculation, about 2/3 of them are practitioners or former government lawyers, and 1/3 are professors. But you can't divide people up in absolute terms in that way, but the balance is roughly 2/3 practitioners, 1/3 professors, I would say. And I think that's a pretty good balance for what the International Law Commission has to do. Its function, as you know, is to implement Article 13 of the UN Charter, And I hope that even if you're human rights lawyers, you always carry a copy of the Charter with you, because it's fundamental to everything we do, which provides that the General Assembly can undertake studies to promote the progressive development and codification of international law. In other words, the General Assembly is not a legislature. It undertakes studies to promote the progressive development and codification of international law, and as part of that exercise, it established the International Law Commission, which itself is not a legislature. It is perhaps, as I've written, a dangerous place, because its output is sometimes regarded as authoritative, stating the law, even when it's perhaps not very good. I think it's very important when looking at the output of the International Law Commission to see what states have said about it, what they have done with it in the International Law Commission. It's the reaction of states to the work of the International Law Commission that matters, in my view, not what the Commission itself does. And particularly, you have to remember that it deals both with progressive development and codification, so its work on any particular topic is not necessarily even intended to reflect existing international law. So, in my view, you have to approach the work of the International Law Commission with all due caution, something that not everyone does, not even the International Court of Justice from time to time. The working methods of the Commission, just very briefly, it decides to take up a topic, it appoints a special rapporteur, the rapporteur does quite detailed reports for the Commission, and in fact I've done 4 reports by now. The Commission then debates the reports in public. It refers proposals to a drafting committee, and in the drafting committee the real work, a lot of the real work is done, but taking account of what's been said in the public debate. And then the Commission adopts draft articles, draft conclusions in this case, together with commentaries. And I can't emphasize too much the importance of the commentaries to any articles or conclusions that the Commission adopts. Unfortunately, the commentaries are often dealt with in a very hurried manner. The Special Rapporteur comes up with a draft, and they're simply adopted by the Commission at the end of its session when it's drawing up its report, with changes, but without the opportunity for members of the Commission to pay too much attention to the details. Because of that, in the case of customary international law, where I think the commentaries are going to be very important, as with other topics, I persuaded the Commission to set up a working group that would look just at the commentaries, and that met for a few meetings at the beginning of the present session in May, and so we have draft commentaries that have now been through the working group, but which will again come before the Commission in August at the time of final adoption of the text. The Commission has adopted 16 draft conclusions on the identification of customary international law, which I hope you have been distributed and you have them in front of you, because a bit later I'll be referring to some of them. As I've said, it adopted those conclusions on the 2nd of June this year. It now has to adopt the commentaries, which will sort of put meat on the bare bones, if you like, of the conclusions. What I anticipate is that there will be 3 parts to the output of the Commission on this topic. The first and principal part will be these conclusions together with the commentaries, which I hope will be a document of not more than about 50 or 60 pages altogether, unlike Professor Pellet's reservations document, which was 650 pages altogether. The second element will be a bibliography on the topic, and a draft bibliography has already been published. You can find it on the excellent website of the International Law Commission. It's about 30 pages long, and it's divided according to the subject matter of the commentaries to some degree. And then the third element is a very practical one. It'll be a further study of ways and means for making the evidence of customary international law more readily available. This is something that the International Law Commission was mandated to do in its statute and did in 1949, 1950, but the world has changed somewhat since then, and life is a lot more complicated when it comes to identifying the materials. There are far too many of them, and it'll be interesting to see what the Commission is able to say about this. What we've done so far is asked the Secretariat of the Commission, which is the codification division of the UN Legal Office, who are an excellent group of people, to prepare a paper that can be looked at in a year or two. And in preparing that paper, they will be consulting with all relevant parts of the UN, of other international organizations, with universities, and generally to try and get ideas as to how to recommend, how to suggest to those who have to study a question of customary international law where to find relevant materials. That'll be a very major task, but a very interesting one. I hope it will be useful. This year, in August, we'll complete the first stage of the topic by adopting, on first reading, the draft conclusions. In fact, they've already been adopted, and the draft commentaries. And then, as is traditional, there'll be a 2-year gap, and the subject will be taken up again in 2018 for a second reading in the light of comments which we hope to get from governments, from international organizations, from the academic community, from specialized areas, NGOs and the like, and it will be interesting to see what comes in. I'll just say a few words about the role of customary international law in the field of human rights. As a general matter, I think it's clear that customary international law continues to play a major part in the international legal system. Those who 50 years ago were predicting that customary international law was dead, that the whole of international law would be codified, put into treaties, that would be that, were never realistic, and they've certainly been proved wrong. As you know, and as was mentioned this morning, Article 38 of the Statute of the ICJ lists the 3 sources of international law as treaty law, customary law, and general principles of law. And then it adds on as subsidiary means for determining rules of law, judicial decisions, and the teachings of the most highly qualified publicists, as they're called. Customary international law is frequently dealt with at the ICJ in a whole range of fields. It's even more frequently dealt with, I would say, in domestic courts, and certainly in the United Kingdom courts. At present, there are 2 ongoing cases of great importance. One concerns the customary international law on the immunities of persons on special missions, where an Egyptian group are contesting a decision by the United Kingdom authorities that an Egyptian general was on a special mission to the United Kingdom and therefore had immunity from criminal proceedings relating to the actions of the current Egyptian government. They're contesting the very notion that there is any customary international law on special missions, despite an earlier decision of the UK courts in the Kurzbat case that there was indeed such law. So that'll be an interesting case to follow. Even more interesting, perhaps, is the Serdar Mohammed case, which is currently before the Supreme Court, which turns on the European Convention on Human Rights, but in particular on whether there is, under that convention, a customary international law, a right under customary international law to detain persons in a non-international armed conflict. And the whole question of what is the customary international law relating to detention in non-international armed conflicts will be before our Supreme Court. So customary international law is certainly alive and well and kicking. Turning specifically to human rights law, it's often thought of as essentially treaty law. If you look in the books, they tend to discuss it largely in terms of the applicable treaties. And of course, there is a very impressive array of treaty law, but I think customary law is still relevant, or is relevant, for a number of reasons. Firstly, and most obviously, not all states are parties to these treaties. Even the covenants have only, I think, 164 and 168 parties, which means there's 25 or 30 members of the UN that are not parties to the covenants. There are some states, Singapore certainly used to be an example, I don't know if it still is, that are parties to very few human rights treaties, and therefore the Singapore courts tend to apply customary international law, not human rights law. Of course, treaties are not forever, as we know in the United Kingdom. I won't repeat what Charles de Gaulle said about treaties, but in short, they're not for life. It's possible that states may leave the European Convention on Human Rights. That's certainly much debated in my own country, though it's been rather overshadowed by leaving other things. Nevertheless, and in addition, there are human rights conventions that have relatively few parties. The Enforced Disappearance Convention has only 52 parties, some 10 years after it was adopted. So customary international law applies in these fields where the treaty itself is not, where a state is not a party to a treaty. It also applies, of course, between states that are not parties to the treaty and states that are parties to the treaty. That is governed by customary international law. Secondly, I think customary international law of human rights is very important in relation to non-state actors, to the extent that non-state actors may be bound by human rights law, and that's the subject possibly of another summer course. It will be customary international law. This is true for international organizations, for example. International organizations are not parties to the human rights treaties. So if they're bound by by human rights law at all, they must be bound by customary international law. That's a very relevant thing for some of the international financial organizations, for example, when they're engaging in projects that might involve a breach of human rights. It would also apply to other non-state actors, such as non-state armed groups, if it's going to be argued that they have any obligations under human rights law, which is perhaps questionable, but nevertheless, if they do, it would be customary international law that would apply. A third reason why it's important is because of the intertemporal law. Judge Ziemler touched on this morning, but customary international law will apply to acts or matters that took place before the states concerned became parties to the treaties as a general matter. That arose in the recent case between Mauritius and the United Kingdom, where there was a big debate, which you can see on the Permanent Court of Arbitration's website, about the time at which the right of self-determination became part of customary international law. Mauritius said it was about 1960. The United Kingdom said it was about 1970. The event in question took place on the 8th of November, I think, 1965, right in the middle of this period. And we debated at great length the date on which the right of self-determination became part of customary international law. But customary international law would apply before, for example, the covenants came into force. Other ways in which customary international law may be relevant, obviously for the interpretation or application of human rights treaties, Judge Siemler this morning referred to the rules of interpretation in the Vienna Convention and the provision that says that you have to take into account relevant rules, other relevant rules of international law. That would include customary international law on human rights. Another matter that could be relevant, or that is relevant, I think, is that arguably you have the parallel existence of customary international law on human rights and the treaty law on human rights. As in the Nicaragua case, where the court held that the law on the use of force existed both in the Charter as charter law, but also as customary international law. The same is presumably true also in the field of human rights. This could be important in practice, for example, if in the domestic courts they have the right to apply customary international law, which is automatically applicable, but not treaty law, which hasn't been incorporated. That's the position in the United Kingdom, which applied the customary law of human rights well before we made the European Convention on Human Rights part of our law. Some people have suggested there's no such thing as customary international law of human rights. Back in the day, Professor Zimmer and Philip Alston wrote an article suggesting that one shouldn't talk about the customary international law of human rights, but about general principles of law under paragraph C of Article 38 of the statute. That was essentially because they didn't think you could apply the rules for the determination of customary international law in the human rights field. I think they were quite wrong on all counts. I think you can apply those rules, as I'll try to show. And I think their argument that you could apply general principles of law within the meaning of the statute of the court, I think was also mistaken. Another general view of the customary international law of human rights is to say that you cannot, is to say that human rights are special, they have a special nature, different criteria apply for the formation and identification of customary international law in the field of human rights. Often they don't really explain what's special, other than to suggest that human rights are very important. On the whole, I get the feeling that specialists in the field of human rights are rather uncomfortable with customary international law. They realize that it's potentially important and useful, but they don't really feel confident in applying the standard approach to customary international law to their particular field. So they come up with new ideas. They talk about modern customary international law, which seems to mean that you don't really bother with state practice, you just look at what states say, you look at their opinio juris, you look at a few resolutions, you look at what a special rapporteur has said in the UN, and you say that's good enough. That's so-called modern customary international law, which I think is not customary international law at all. It's something else, it's not based on practice. Sometimes they use that awful term, general international law. That's a term I try to avoid. I try to encourage people to avoid, but I don't succeed. The International Court tends to use it all the time. The term general international law, to my mind, is pretty obscure. I think you should only use it if you're going to define what you mean by it. But it's just a convenient way of shading over the fact that this treaty's in the field, that there's declarations here, there, and everywhere. So you just refer to general international law and hope nobody's noticed that you're not really applying the rules of customary international law. Others argue that everything derives from, let's say, the UN Charter, from those very general references to human rights in the UN Charter, And they say, therefore, you can look at the declaration, the Universal Declaration of Human Rights, which implements the Charter, so that's all law. Numerous other UN declarations, soft law. This was the approach taken at least some years ago. I won't mention by whom. And then, coming back to this modern international law, they de-emphasize or rule out the need for two elements. They downplay the requirement for a general practice, almost a vanishing point, and they advocate exclusive reliance on the subjective element, opinio juris. I'll now turn briefly to the work of the International Law Commission in the field. Firstly, why did we take on this work? Well, I think one reason is because customary international law is coming up more and more for consideration by lawyers who are not experts in the field of international law. On the whole, you can trust public international lawyers, those who have been brought up in it, those who are trained in it, to approach customary international law in a reasonable way. But when it comes before, say, a domestic judge who is not a public international lawyer, or before other lawyers, advocates who are having to argue a case where customary international comes in, but they're not experts in the field, there's considerable difficulty, and certainly some of the English judges have said to me they don't know where to look, that you can look in all the books, they all tell you different things about customary international law. It would be quite useful to have some more or less authoritative guidance on the subject. Guidance that can't be dogmatic, it has to leave flexibility, but nevertheless is some guidance. Similarly, with Jus Cogens. Jus Cogens is constantly coming before the English courts now, and the judges just don't know what it means, what it is, where to find it, and above all, what its consequences are. And again, that's the reason, I think, why the International Law Commission has now taken up the topic of Jus Cogens, very much in the same spirit as it's taken up the topic of customary international law. What we're looking for is something that's quite practical. We're not trying to resolve all the great theories that you find in the numerous writings. They're referred to in the bibliography. But in terms of trying to be helpful to practitioners and to courts, the Commission is steering clear of theory as much as it can and coming up with practical guidance. Just a word about our methodology. Where did we look to find out what the methodology is for determining and identifying rules of customary international law? Well, the first place is Article 38 of the ICJ statute, which in a sense tells you all you need to know. It refers to international custom as evidence of a general practice accepted as law. So you have to have a general practice that is accepted as law. The ICJ statute, of course, in terms only applies to the work of the ICJ, but it's generally accepted as reflecting the sources of international law. It's been repeated in many other instruments. It's the first thing I was taught when I learned international law. Now, there's considerable guidance on methodology from the decisions of the International Court of Justice itself. Big decisions like the North Sea case or the jurisdictional immunities case, but also in many other decisions you get detailed guidance, wording that can be picked up and used. We found that very useful. We also looked at the decisions of other international courts and tribunals, including, for example, the international criminal courts. That's an example where you have judges, even of an international court, who are not necessarily experts in public international law. We tried to look at state practice. What have states said about the methodology for identifying customary international law? There's relatively little. Some of the reactions to the ICRC's study of customary international humanitarian law give an indication as to the way the states think, but there was relatively little. However, as a result of the International Law Commission taking up the topic, there's now quite a lot, because we have many states who've reacted to what we've done, who've made statements in the Sixth Committee. Perhaps 60 or 70 states are on record now as stating what they think the rules are for, or the methodology should be for identifying customary international law. So it's one of those cases where the very fact of taking up a topic leads to at least materials from which you can take the topic forward. So looking at the draft conclusions very briefly, and then I'll try to stop, you'll see they're divided into a number of parts. Part 2 states the basic approach. I'll come back to that. Part 3 says a few things about the first element, a general practice. And Part 4 says a few things about the subjective element, acceptance as law, often known as opinio juris. Then we come to a Part 5, which is really supplementary, and it deals with 4 particular sets of materials that may be of particular importance for identifying customary international law. Treaties, resolutions of international organizations, decisions of international courts and tribunals, and teachings or writings. And then finally there are 2 parts at the end dealing with specific issues. One is the persistent objector rule, and the second is the question of what we call particular customary international law, often referred to as regional customary international law. And I think there's a lot of material here that is relevant also for those working in the field of human rights law. Draft conclusion 2 is central, and it states the basic approach. It says that to determine the existence and content of a rule of customary international law, it is necessary to ascertain whether there is a general practice that is accepted as law, opinio juris. Now, that may be stating the obvious. It is stating the obvious, but it's quite important to state the obvious when so many writers are coming up with their own theories, one-element theories, predominance of one element over the other theories, sliding scales, and all kinds of nonsense of that sort. So stating the obvious is quite important, and it is significant that all states who've spoken on the matter in the General Assembly of the United Nations have endorsed this basic approach. Not one has suggested there is some other method that should be employed. Now, a central question is whether the methodology varies across different fields of international law. In other words, are there different approaches to the identification of customary international law in such fields as human rights law, humanitarian law, international humanitarian law, international criminal law? Is it the case that one element may suffice in relation to these, for example, opinio juris? The answer we've given is very clear. There is one basic approach. We don't say there are exceptions. And in my view, that's right. I think that if we're dealing with what can properly be called customary international law, practice and opinio juris are essential. I think a unified approach is consonant with the notion of international law as a single legal system, a single legal order, if you like, which should not be divided up into separate branches, each with its own approach to sources. Now, having said that, I would acknowledge, and the Commission acknowledges, that there may be differences in how you assess the evidence depending on the nature of the rule rather than the field of law, I would suggest, and the particular circumstances in which the evidence is to be found. So the basic approach is the same, but the way you weigh the evidence, where you look for evidence, will naturally vary depending upon the area of law concerned. The International Court said that, or said much the same in the jurisdictional immunities of the state case, the Germany-Italy case, where they were looking at the customary law on state immunity, and they said, in the present context, state practice of particular significance is to be found in the judgments of national courts, in the legislation of states to have legislation, etc. And then it went on, opinio juris in this context is reflected in particular in the assertion of states claiming immunity, etc., etc. So the court itself said, in the context of looking for the rules on state immunity, you pay particular attention, or you're going to find the evidence in particular ways. And I think the same is true of the human rights field. Now, I'll just mention a few long-standing controversies relating to customary international law, which I think the Commission has responded to, and I'd like to think answered. And I think they're each relevant in the field of human rights. For example, it's no longer, in my view, contested that verbal acts, and not just physical conduct, may count as practice. And that's reflected in draft conclusion 6. If you look at that, it says expressly that practice includes both physical and verbal acts. Secondly, it's no longer seriously suggested that a particular duration is required for the emergence of a rule of custom, provided that the practice is general and accepted as law. You don't need a particular period of time to pass. Lawyers of the past used to say, it has to be since time immemorial, or it has to be for 30 years, or whatever. That we have clearly ruled out in draft conclusion 8, where it says, provided that the practice is general, no particular duration is required. Which is not to say that you can have instant customary international law, because you have to have some practice, and practice does imply a certain period of time. A third and very important issue is that the practice has to be general, but that does not mean that it has to have complete consistency. Some consistencies, some contradictions, some breaches are not necessarily fatal to a finding of a general practice. And here you'll recall the approach of the International Court of Justice in the Nicaragua case, where it said that inconsistency taking the form of breaches of a rule, we might think of the rule against torture, for example, do not necessarily prevent a general practice from being established. That's particularly so where the court concerned denies the violation and expresses support for the rule. That was the situation in the Nicaragua case. An important issue that we've addressed is whose practice counts for the purpose of identifying rules of customary international law and its content. That's dealt with in draft conclusion 4, which has 3 paragraphs. The first one states that the practice of states is of primary importance. That's self-evidently the case. Paragraph 2 concerns the practice of international organizations, and that says that in certain cases, such practice also contributes to the identification of rules of customary international law. This is talking about the practice attributable to the organization itself, as opposed to the practice of states that takes place within the context of an international organization. And it's really quite controversial. There's no agreement in the Commission yet on the proposition that the practice of international organizations may count. No full agreement, but there's certainly a majority view that it does. And if you think about an organization like the European Union, which has exclusive competence in many fields, which acts instead of its 28 member states, it would be hard to deny that its practice should count towards the formation of customary international law. If you did, you would be denying 28 states the possibility of participating in such practice. But I see there's a question from the back.
Would it make a difference if we would separate the organizations between the ones which are the organizations of cooperation and on the other hand the organizations of the integration?
Yeah.
Difference, right? So the level of cooperation the relationship between the states is not the same.
Well, that's certainly true, but it's much more subtle than that, I think. A lot depends upon whether the organization has a particular role in relation to a matter. For example, the practice of the United Nations as a depository of treaties is certainly, I would say, relevant and important for the law on the role of treaty depositories. The practice of organizations in claiming privileges and immunities under customary international law, which incidentally they do a lot of the time, is, I would say, relevant to the customary international law on the privileges and immunities of organizations. Certainly the practice of all organizations that have treaty-making power must be relevant to the development of the customary international law of treaties between organizations and states or between organizations. So there's a lot of fields where I think particular organizations have their practice must be relevant. Another question is what weight you give that practice as opposed to the practice of states or as opposed to the practice of other organizations. Does the United Nations have more weight than some very small organization? I don't know if the Institute's an international organization, but I'm sure its practice is very important. Anyway, so this is something that we'll certainly be covering in the commentary and trying to resolve in the commentary what we mean by in certain cases and do it in a way that is flexible enough to get general agreement within the Commission and even more important, to get acceptance by states and others in due course. Please.
Yes, I have a question about practice, because practice can be from a state that the state itself is not something what can practice, so it's by people state, and what if there is is there a conflict between the practice of two people from the state?
Well, that's a very good question. It's one that I think we've dealt with and will be dealing with. We have a provision that says in looking at the practice of a particular state, you have to take account of all the practice. I think it's draft conclusion 7. Account is to be taken of all available practice of a particular state, which is to be assessed as a whole. And then we say where the practice of a particular state varies, the weight to be given to that practice may be reduced. But you might have a case where the Supreme Court says one thing about public international law, and the executive says it disagrees. Says we accept that as a matter of domestic law because it's the Supreme Court, but internationally we don't agree with that, and we're going to try and persuade our courts to change their mind. There you've got a very interesting question. Is it the executive that counts more than the courts in international relations? I would say, being an executive-minded person, yes, on the whole, but actually you have to look at the constitutional position within each country. It may be that in some countries the Supreme Court has more authority, even in international affairs, than the government. Please.
I have a small question concerning to the practice of international organizations, especially when court is involved in the issue. For example, concerning to the European Court of Human Rights, we already know that it has developed a very strong case law that has been able to create very great principles in order to protect the rights and freedoms of the people that are within the legal space of the Council of Europe. Can the case law of the European Court of Human Rights constitute some kind of practice that can bound the states in it, and that can this practice engage the responsibility of the states in one or other way, especially concerning to issues of non-state actors or extraterritoriality issues?
Well, these are some very big questions. There is a publication coming out in a couple of months in which I think Judge Ziemler discusses the contribution of the European Court of Human Rights to customary international law, and in particular, of interest to me, the methodology being used. This is a Council of Europe publication which deals with a lot of domestic courts, international courts, and has contributions from about 20 people. I think that a point I'll come to right at the end, but I'll mention just now, is whether there's such a thing as regional customary international law of human rights. For example, if perchance a state were to leave the European Convention on Human Rights, but still be part of the region, would there be some regional law of human rights of the same level as the European Convention, which is different perhaps from the universal level, a regional level of human rights that would continue to apply to that state because there is such a thing as regional customary international law? And I think the decisions of the European Court of Human Rights might be very important in that regard. There's no serious practice on this matter, though there is an opinion of the Federal Foreign Ministry of Switzerland saying that there is a regional European customary rule of non-refoulement. That's from about 10 years ago, 20 years ago, before people thought there was a general customary international law of non-refoulement, which perhaps there is, perhaps there isn't. These things will all become very important in the English courts if the United Kingdom leaves the European Convention on Human Rights, which I hope will not happen, but it's certainly being discussed. I won't say any more about international organizations. You can read the commentary when it comes out. It will actually be published in 2 or 3 weeks online as a draft, the draft I've submitted, but the final version will be adopted in August. Just to point out then that the third paragraph of Article 4 says quite firmly that the practice of other actors is not, conduct of other actors, that means other than states or international intergovernmental organizations, is not practice that contributes to the formation or expression of rules of customary international law. But it goes on to say, but it may be relevant when assessing the practice referred to of states and organizations. This is to say that what NGOs do, what the ICRC does, may be very important in stimulating practice, in recording practice, in summarizing the practice of others, but it is not itself practice that contributes directly to a general practice in the sense of Article 38 of the ICJ statute. And the commentary is likely to say that the official statements of the ICRC, such as their appeals and memoranda on respect for international humanitarian law, play an important role in shaping the practice of states, reacting to such statements. And publications of the ICRC may serve as helpful records of relevant practice. Such activities may contribute to the development and determination of customary international law, but they are not practice as such. The same, I think, would be true of organizations like Human Rights Watch, Amnesty International, and others. That view of the ICRC is, I think, also the position of the ICRC. At least I've tried to check with them that it is. Now, I'll just move very quickly through the remaining points to open it up for discussion. Firstly, the relationship between treaties and customary international law is a very old argument, pretty well established, I think, in the case law of the International Court of Justice, and it's reflected in draft conclusion 11. More controversial in the past, anyway, is the relationship between resolutions of the UN General Assembly, for example, and customary international law. And here, draft conclusion 12 is more cautious than the one about treaties. It starts off on a negative note. It says that a resolution adopted by an international organization cannot of itself create a rule of customary international law. So the mere adoption of a resolution or a series of resolutions purporting to lay down a rule of customary international law doesn't create such a rule. You have to establish the rule from other evidence. That, of course, was a very controversial issue when the International Law Association, which is a private organization, did a rather similar exercise to what's being done now. In the year 2000, it adopted a statement of principles on the formation of general customary international law, and it nearly fell apart, and if you read the record of the last meeting, on this question of resolutions of international organizations. I get the impression it's nothing like as controversial now. I think that reflected a time some time ago, 20 years ago, when there was much more controversy in Northwest, the sort of the North-South dialogue and other things had infected the discussion of resolutions. Now, essentially it's the same as treaties. They can and they cannot. You have to look very carefully at them, but they can contribute significantly to identifying rules of customary international law. The next provision is 13, about judicial decisions. I needn't say much about this. According to the ICJ statute, they're only a subsidiary means. Going back to what was said this morning, they don't create law, but they may reflect law. They may be, they have at least two functions. International court decisions fall within paragraph D. They can contribute to the determination of rules of international law, including customary international law, through the quality of the argument, etc. But national court decisions, which are also within the ICJ statute, subparagraph D, though some people, for example in France, say they're not, that it's only referring to international decisions, but it doesn't say so. So there can be a supplementary means within the meaning of 38.1d, and that's what this provision 13 says. But they can also, of course, and perhaps more significantly, national decisions are a form of state practice, though they have to be weighed against other state practice, as I mentioned earlier. So decisions are pretty straightforward, I think. The same is true of draft conclusion 14, I think, on teachings, where we tried to modernize the language from the International Court of Justice's statute dating from 1920, but we came back to the same language, teachings of the most highly qualified publicists of the various nations. Teachings we thought was better than writings, because our German member thought it suggested more dignity. It probably is a better term. It also includes teachings that are oral as well as written. We kept the expression publicists, which is a very strange expression to an English lawyer. In fact, it sounds like a journalist. But I understand that it actually means publiciste. It means somebody who is an expert in public law as opposed to private law. Of course, in England, we're all experts in everything. But even though it says publicists, of course, there are many good international lawyers who are not necessarily public lawyers. And I think the term now has to be read as meaning anyone who teaches or who writes. Most highly qualified we kept, though my own view, it's not a matter of the qualification of the person, it's a matter of the quality of the writing. You can have very bad writings from very highly qualified people and vice versa. Of the various nations is important, obviously, although it's very difficult, you have to take account, insofar as you can, of writings from all regions, particularly from all legal systems, and ideally in all languages, which with Google Translate is a bit easier than it used to be. And then, just to mention, well, firstly, before mentioning that, just to remind you of what I think is an excellent statement by the US Supreme Court about writings in the Paquete Habana case, explaining that they are really subsidiary means. And it says, the works of jurists who by years of labor, research and experience have made themselves peculiarly well acquainted with the subjects of which they treat, such works are resorted to by judicial tribunals not for the speculations of their authors concerning what the law ought to be, but for trustworthy evidence of what the law really is. So I do think it's incumbent upon writers to make it clear whether they are stating what they think the law should be or stating what the law is. They often don't make that distinction. Just very quickly, draft conclusion 15 sets out the persistent objector rule, on which there was agreement within the Commission, and there was a lot of support within the UN General Assembly, with one or two dissenters. That's the rule that says when a state has objected to a rule of customary international law while it was in the process of formation, the rule is not opposable to the state so long as it maintains its objection. Question arises whether you could be a persistent objector to a rule of customary international human rights law. Well, I think it's generally accepted you can't be a persistent objector to a rule of jus cogens, though that's a matter we'll deal with under the jus cogens item. But not all rules of human rights are jus cogens. So there is a really interesting question whether you can be a persistent objector to certain customary international law rules. And then finally, draft conclusion 16 deals with particular customary international law, that's regional, local, bilateral customary law, etc. And that raises very interesting questions in the field of human rights, which I've already touched on.